Welcome to episode 76 on the law report. And I confess that this should have been episode 1 because when I initially started this channel, my intention was to focus solely on the criminal law. Over time, I have diverted into other areas of the law. But today, I'm going to deal with the general principles in criminal law. Before I do, my usual disclaimer. This is not legal advice, should not be construed as such. For legal advice, please contact an attorney of your choice. Welcome back. The general principles of criminal law is a very important discussion in the area of criminal law. But before I get into the principles, the first question to be answered is, what is criminal law? Criminal law is an area or field of law which deals with crimes that are determined to be detrimental to society as a whole and are punishable by laws passed by Parliament. Specific criminal law will explain what constitutes the crime the law seeks to prohibit and establishes penalties for individuals who are in breach of the law. In contrast, civil law deals with conflicts between individuals or organizations and focuses on compensating or restoring the injured party to its former position rather than punishing the offending party. Civil law is sometimes referred to as private law, while criminal law is referred to as public law. The key distinction is that criminal law is concerned with punishment for the good of society, while civil law is concerned with compensation for the benefit of the injured individual. The corpus of rules that apply to all criminal acts, regardless of their precise character, is generally known as criminal law. It provides the basic concept, processes, and safeguards that apply to those accused of committing crimes. Some of the most important features of the criminal law are as follows. Criminal law outlines what behaviors are deemed criminal and the penalty for committing such crimes. Criminal intent is a concept of law where in order to be found guilty of an offense, a person must have the particular criminal intent to commit that particular offense, or that the person was reckless as to the outcome of the actions, which was reasonably foreseeable. At the heart of the criminal law is what is called the presumption of innocence. In the Turks and Caicos Islands, it is a constitutionally protected principle. Everyone is presumed innocent until or unless proven guilty. In order for a person to be proven guilty of a criminal act, the prosecution has what is called the burden of proof. The prosecution has the burden of proving beyond reasonable doubt that the defendant has committed the offence for which he or she is charged. Another principle at the heart of the criminal law is the right to counsel or the right to a lawyer. Individuals charged with a crime have the right to an attorney of their choice. This is also a constitutionally protected right in the Turks and Caicos Islands. There is also the principle of due process. Everyone has the right to a fair trial within a reasonable time, including the right to a jury of their peers, which in the Turks and Caicos Islands can only be denied under exceptional circumstances. And they also have the ability to question witnesses or to confront their accusers. And at the end of the process, there is the sentencing. And this is premised on sentencing guidelines, which is established in the criminal process, which set out rules for sentencing those who are convicted of crimes. I will deal with the principles of sentencing in a subsequent episode. What I've outlined are some of the most basic, important criminal law principles that apply to all criminal proceedings. It is crucial to remember that criminal law varies by jurisdiction. Therefore, in separate jurisdictions, the law will be different. Now, at the heart of criminal proceedings is what is called evidence. And the evidence is information or testimony given in court to show or to refute that an accused person is guilty of the offense for which he or she is charged. Evidence takes many different forms, including one, physical evidence, which refers to physical things associated with the crime, maybe a firearm, fingerprint, DNA samples, clothing, palm print, a footprint, etc. There is eyewitness testimony, which refers to those who saw the crime or the circumstances leading up to it. There is expert witnesses. This is testimony provided with persons with specific understanding of a certain subject matter, such as forensic, medical experts, forensic scientists. In other words, those who can provide expertise outside of the knowledge of the court. Then there is documentary evidence, which refers to written papers relating to the crime, such as maybe email, contracts, bank records, phone records, etc. These are only a few categories of evidence that may be submitted and deemed admissible during a criminal trial. The sorts of evidence that may be admissible in criminal proceedings may vary from jurisdiction to jurisdiction, but the basic purpose is to give facts that will allow a jury, or in the case of a trial by judge alone, the ability to make a fair and accurate evaluation of the accused's guilt or innocence. Now, one thing that will run through the whole criminal system is what is called criminal procedure. These are rules and processes that regulate the execution and administration of criminal law. They outline the procedure that law enforcement authorities, prosecutors, and even the court itself must follow during a trial, during investigation, during prosecution, and for punishing anyone convicted of a crime. Criminal procedure also describes the right of the accused, his right to an attorney, his right to remain silent, his right to a fair trial, and the procedures that must be followed to ensure that those rights are maintained. Criminal procedure also encompasses the regulations for gathering, storing, and presenting evidence. It may also touch and concern the basis of plea, which I will deal with in a subsequent episode, the criteria for granting an arrest or search warrant, and the process for appeals against convictions or decisions of the court. So the purpose of the criminal process is to guarantee that the criminal justice system functions fairly and effectively while also protecting the rights of all parties. And at the end of it all, if a person is convicted, comes the sentencing. Sentencing refers to establishing or determining the sentence that will be imposed on a convicted person. The goal or the purpose of criminal sentencing is to hold a convicted person responsible for their actions, to protect the public, to provide the accused with a chance of rehabilitation and reintegration into society. So the sentencing court must find a balance between all these competing factors to arrive at the appropriate sentence. The particular sentence imposed will be determined by the nature of the offense, the individual's criminal history or good character, the sentencing guidelines in the jurisdiction, and taking into consideration what is called the mitigating and aggravating factors into consideration, such as the defendant's remorse or regret in committing the crime and his criminal record, the victim impact statement, etc. The purpose of criminal sentencing is to ensure that the penalty is appropriate, proportionate, and just in all the circumstances. And it also takes into consideration the facts of the case. Here is where I will leave it for today. I thank you for watching. Hope you have learned something from this episode. If you do, please like, share, and comment. And I will see you very soon in another episode.